I am appealing to the relevant authorities to reconsider the minimal bail clause in light of the granting of bail to someone who was recently charged for possession of 9 fully automatic weapons of war, together with magazines. Several assault rifles in the hands of criminal elements may result in the death of hundreds of people in seconds. Yet when persons are apprehended in possession of these types of weapons, the present criminal justice system appears flawed and at times favoring the criminal elements rather than the potential victim. When granted bail, these offenders can very well access another illegal firearm to continue attacking the state and law-abiding citizens. This is with one weapon. So imagine those who may have been held with possession of 9 assault rifles. The Trinidad and Tobago Police Service is in a virtual war out there, given the types of weapons that the enemies of the state carry. But when these individuals shoot at us and we return fire to defend ourselves, we are interrogated and at times condemned. Likewise, when we capture them, whilst holding them with the types of weapons that can kill dozens of innocent citizens in seconds, orders are then given in 24 hours or less that they can be released, allowing the enemy of the state to then go back into the killing fields to acquire another firearm. This is certainly not a level playing field, and at times we are left to wonder why the controllable odds are being stacked against not only the police, but also the law-abiding citizens. The previous law prior to the sunset clause worked, whereby if held, the offending party would be without bail. As such, the likelihood of being allowed the opportunity to acquire additional weaponry or even the potential for a vengeance move is effectively blocked. As a result of the recent parliamentary adjustment to this clause, persons held with illegal firearms, be it 1 or 9, handheld or semi-automatic, they are afforded access to bail once they do not have a previous conviction. At some point, whilst adhering to the law, the gloves must come off. In apprehending persons, is it that we must now hope that they would have a previous conviction for an illegal activity, such as being in possession of numerous illegal automatic weapons, before we keep such elements off the street? Why would someone have such an arsenal in their possession illegally? How are the officers of the TTPS to function effectively when they believe that they are operating with a revolving door that seems to benefit the perpetrator? 1 automatic weapon has the potential to eliminate dozens of innocent lives in an instant. What about 9? Why do we have to wait for someone to actively engage and cause havoc before decisive action is taken? Whilst offenses such as bounce checks and other types of fraudulent activity are not to be trivialized, certainly such offenses are to be weighed differently in those of persons held with illegal weapons that can be used with an intent to kill. While it is a person's constitutional right to bail, the Bail Act contemplates the seriousness of the offense when a judicial officer must consider bail. So it is indeed curious about what message judicial officers are sending to the nation when persons are alleged to have been found with assault rifles which can kill hundreds of persons in the blink of an eye and can so easily access bail to perpetrate similar offenses possibly on law-abiding citizens. It is noteworthy to mention that while I recognize that the bail amendment bill recently passed was made with the best intentions, it is not as effective as it should be in its current form.